Good morning. Apart from our indulgence in understanding civil law, but understanding the other aspect of execution of documents, execution of will, execution of gift, execution of settlement deed uh, is a knowledge one must have, even though you are not practicing civil side or you are not even an advocate, but an ordinary prudent man living in society with multiple issues of legal heirs, brothers and sisters. Uh, so many things are there. So to understand that the problem is normally uh, the the execution of one document is what, whether it is will or gift or settlement deed. So the law says that the nomenclature is not important. The contents of the document is important. That was Indian Succession Act says. Indian, you know that law of interpretation and the law of um, reading out principles. See, the Indian Succession Act deals with so many provisions as to understand the documents and other deeds being executed. So it is far better you go through that. His judgment is going to help you, the aspiring students appearing for the examination, having multiple judgments. The judgment was written by Justice Mahadevan, our Mahadevan. This is AAR 2025, Supreme Court 1987. AAR 2025, Supreme Court 1987. Dated 24/3/2025, N.P. Sasidharan versus N.P. Ponnamma and others. The father seems to have executed a gift deed in favor of the daughter. Thereafter, he seems to have revoked it unilaterally. Unilaterally means without informing the daughter, and thereafter sold the property. So suit was filed by the daughter for declaration of title. The nature of instrument is a settlement deed. Then also she claimed some cancellation of sale deed executed by the father. The suit was dismissed by the lower court, and appeal was also confirmed in favor of the father, but the High Court RSA bench set aside both judgments, instead decreed the suit in favor of the daughter, declaring that the document is settlement deed and the unilateral cancellation of deed is void. The registration authorities cancellation sale deed is also void. So these provisions are Transfer of Property Act 122, Section 5, Succession Act, Indian Succession Act 63 were discussed. Interplay between gift, settlement and deal, will was discussed. Then Section 126 and 122, declaration of title was discussed. So many judgments were discussed. Apart from that, I would like to ask you to go through the paragraph 3 for the facts of the case. Then you must understand the paragraph 15. Paragraph 15 is discussing about what was the consideration, how to understand the consideration being mentioned or some document has been executed for consideration. They are discussed about so many: Webster Dictionary, New International Dictionary, Corpus Juris Secundum, and Scotland Jurisprudence, and also so many things have been discussed along with Chidambara Iyer versus P.S. Iyengar judgment. Several judgments were discussed. Renikunda Rajamma versus K. Swarnamma, Then at paragraph 11, they have discussed about section 124 to 129 about gift and acceptance of gift. Here, after registration of gift deed, the father handed over the gift deed to the daughter, and but unfortunately, because the father retained his life interest to collect the rent, the daughter was not residing there. So that objection, that since she was not residing, that was not that gift is not valid, and they claim that it was will, and subsequently the father died during pendency of litigations. His sons were brought on record, and one of the sons was subsequently deleted. So the paragraph 11.4 of the judgment, paragraph 11.4 of the judgment says, interplay between gift and will. What is different between gift and will? Then they say at paragraph 11.5, gift, settlement and will interplay. So they finally have given lot of information, so which will enable you to understand the method of writing documents, drafting. So this at paragraph 14.1, the legal position was settled for gift or settlement. In case of postpone of such transfer until the death of the document is to be treated as the will. The fact that the document is registered cannot be the sole ground to discard the contents and treat document as a gift, just because which is to be ascertained. The nomenclature given to have irrelevant. The contents of the document have to be read as whole and understood. So here they are categorically discussing all. They have held that when under a will tested as bequeathed is absolute interest of the proper wife, any subsequent bequest which is repugnant to the first bequest would be invalid. These all are been discussed, and they also discussed about section 85 of the Indian Succession Act. Then 86 at paragraph 21, paragraph 20, 86, 85, para 21, 86 and 87. After discussing all that, the claim of the father and their legal heirs that the executed document was will not accepted. So to come and dip yourself in this ocean of civil law, not only to become a powerful civil lawyer, but to have armed with your personal knowledge of dealing with the properties. I hope you understand. I thanks all my friends, juniors, relatives, and that who have conveyed me best wishes for my 72nd birthday, and which was celebrated by them on yesterday, 29th June 1954. But actually my date of birth on record is 3/7/1953 as per this email communication, Facebook, etc. etc. So to understand the entirety of judgment, you have to spend hours together by reading every paragraph one after other, and they have discussed about Wynor's case. Lord Coke had dealt this judgment about true character of instrument propounded by the appellant. These things are there. The wordings is most important in documents, will. So kindly go through the judgment, will help you to understand the best civil lawyer. So try to understand not to be a civil lawyer alone, but as a capable social head, family head, to deal with the properties. Must know this, all these things. Best wishes. Another thing was that here the dictionaries which is referred by these courts, all are available at Madras High Court Advocate Association as well MBA association, as well in my chamber and also in my residential office. But I could not see any advocates uh, at least test the book's cover. So all right, namaskar.